So, from the prosecutor's perspective, President Lawrence used to be an assistant United States attorney in the Southern District of New York. There was a piece, an op-ed in the Times today called Gideon's Muted Trumpet by Paul Butler. Bill and I were talking about this beforehand. Paul Butler is a professor at Georgetown Law School, former assistant United States attorney. And he says about what he calls the unfulfilled promise of Gideon, that 50 years after the Supreme Court in Gideon guaranteed legal representation to poor people charged with serious crimes, low-income criminal defendants, particularly black ones, are significantly worse off. And what he says, and the question for you, he says, don't blame public defenders who are usually overwhelmed. The problem lies with power-drunk prosecutors. He says, I know because I used to be one, and tough-on-crime lawmakers. From your perspective, where in the overall responsibility for the administration of justice do the sentencing guidelines and the discretion that prosecutors have fit into this conversation?
Well, let me start with a full disclosure. Paul Butler, who you referred to in that article, is a dear good friend. Before he was on the Georgetown Law faculty, he was on the George Washington University Law faculty. And you'll forgive me a parochial moment if I say that I'd like to think that had I stayed there, I could have kept him. And it just so burns me to think that we lost him to the crosstown rival over at Georgetown. Right, that part of the program is now done. Now I can get to your question. Paul is a distinguished scholar and has written a work that I recommend to all of you with the unlikely total of Let's Get Free Towards a Hip-Hop Theory of Justice. Very intriguing, provocative book. As a matter of fact, just one more point of digression, if I might. Every time Paul wrote something, I knew that my next day at the office would never be lonely, because my phone line lit up with alumni who said, how can you let a guy like that be on your faculty when he writes all these crazy things? Paul's thoughts were just crazy enough to be true, and that's what makes him so provocative and so important. One of the things I think that came across in his remarks so powerfully, and maybe went by too easily, is that word passion kept coming up. And my guess is that if you had the chance to read the Gideon opinion, the word passion may not be what sort of leaped to mind, because it's written in a careful legal argument, crafted constitutional interpretation. Hugo Black was a senator, but a lawyer who really thought these things through carefully. He was a strict constructionist who looked at the text and tried to see what was implied by the text and meant by the text, and then to apply that. So where's the passion coming from? The Gideon decision is best understood as part of what was known as the due process revolution during the late 50s, but particularly the 1960s, and associated primarily with the Warren Court. A whole series of decisions, and you know some of them. You know the Miranda case of warnings that a defendant is entitled to, but there's a whole range of them that you probably know less well, that really were designed to revolutionize the protections, the procedural protections that people were given. And I think up until the due process revolution, in many ways, one thought of protections of the law as substantive protections, rights that you had under the law. But the genius of the due process revolution was that if there are not procedural protections put in place, all those substantive rights don't mean anything if there isn't some way to enforce them procedurally. The late Alexander Bickel was one of the great legal scholars of our time, and just to put in a plug, happened to clerk for a Supreme Court justice by the name of Louis Brandeis. It always comes back to Louis Brandeis if you stick around here. Bickel wrote that the only true integrity is the integrity of process. The only true integrity is the integrity of process. And what he really meant by that was that the system's got to be fair from the get-go, and then it's going to come out the way it comes out. Sometimes people are going to go to jail. In fact, with all due respect to Paul Butler, sometimes poor people are going to go to jail. And sometimes poor people are going to go to jail when you might actually be able to argue that had they been born in different circumstances, they would have made different choices. I don't think Bickel would have a problem with that. But Bickel would certainly say, damn it, they better have a good lawyer to be able to represent them. Otherwise, there's no integrity of process. So where does the passion come from? I think the passion comes from the fact that this integrity of process, this due process revolution, was really built along the notion that everyone who's a member of society starts with certain inalienable rights. We know where that comes from. but then has a right to have them enforced, and here's the payoff, it triggers certain obligations of the government back to help enforce them. That the government has certain obligations to make those rights enforceable. That's what it means to be a member of the community. So applying this in the case of criminal defendants is actually a very powerful insight. Because probably nowhere more than in the criminal justice system is it very easy for us to fall into the habit of the sort of we-they stuff. We are the law-abiding members of society, and they are the bad guys who deserve to be punished. And the genius of the due process revolution was to say, there's only we's in this story as long as the eye can see. Everyone who's a member of the society is in the we category. And they're all entitled to certain rights that are enforceable against the government, have to be protected by the government, and one of those rights is the Sixth Amendment right to a fair trial, and that requires the right to a lawyer to enforce that. And then the chips fall where they may. Now, Paul's point that at some point that prosecutors have obligations in the system and that's part of where the Gideon dream has not been realized, I think goes back to this we-they point. I was trained as an assistant U.S. attorney in the Southern District of New York to use the line from a very famous Supreme Court decision that prosecutors are obliged to strike hard but fair blows. And that our job was not to see that the government won, it was to see that justice was done. And I know perfectly well that sounds unbelievably corny to you guys. But we really were trained to think that way. And it's a very powerful point to say that unlike a private lawyer whose job is to represent his or her client zealously within the bounds of the law, that means really to try to win. And then the other lawyer does the same thing. And through that tension, through that process, comes justice. That is not the obligation of an assistant U.S. attorney. It is not to see that your client should win. It is to see that justice is done. Strike hard but fair blows, which means sometimes you're supposed to lose. That's what it means to be a prosecutor. That is, in fact, in the early 1980s, when I started at the U.S. Attorney's Office, how we were trained. Even the defendant is part of we. And I'm over-romanticizing it ever so slightly, I'm sure. Which is to say, it was not always carried out, to be sure. And were there power drunk, is that the line? Power drunk prosecutors?
Power drunk prosecutors.
Power drunk prosecutors. Yeah, Paul's got a pretty good way of turning a phrase. Were there power drunk prosecutors in the U.S. Attorney's Office when I was there? There might have been a couple. No one I knew. But the point is that that was contrary to the way in which we were supposed to be trained. I think the real challenge in the criminal justice system generally is to break down that we-they stuff. Because I think once the we-they stuff comes into place, then it becomes not a process to determine the outcome of whether people are guilty or not. It becomes a process to convict people who are assumed to be guilty. If you're just processing the chow, to use Tom Wolfe's colorful expression from Bonfire of the Vanities, if you're just finding a way to process guilty people and put them in jail, then the truth is, why bother with the expense of giving them a lawyer? But on the other hand, what you're really doing is validating the rights of every member of society. To see how that outcome ought to come out, how that case ought to come out, then you do need the lawyer representing them, and the prosecutor's job then is to see that the right outcome happens. I think Paul raises a powerfully important challenge to his former profession and mine.